That is what we intend to avoid.
Honorable member. Honorable member, please. I don't know how many times I have to draw the attention of members to this matter. That is not what is before us. Finality of the rule of law is pronounced and is in the bosom of the courts. Legislative power, the power to make laws, is in our bosom. The Constitution added the power to approve, that is, give prior approval to nominees by His Excellency the President. And that is exactly what we are doing. As to whether our decision is the final rule of law, is for another body to determine. And so the proper venue, and I keep on emphasizing that, is not this house, it's the court. And so please, once you have the matters pending there, the matters will continue to pen there, and you can vindicate those rights there. The judiciary cannot say that because Parliament is considering a bill that may have some effect on a matter before the judiciary, they'll have to hold on until we pass the bill before they proceed with the matter. They can't say that. The same, I'm just putting it in simple language, that once
making my contribution, I would want to, in addition to the report, rely on the certified copy of the verbatim report of proceedings that has been served on my good self by the clerk through the chairman. And for the avoidance of doubt, I would want to make same available to the table office for the record, because I'm going to rely on same. Mr. Speaker, that said, I shall proceed to say that for the first time under the 1992 Constitution, a sitting Chief Justice has been removed pursuant to Article 146 of the Constitution. Mr. Speaker, that removal effected on 1st September 2025, following recommendation by a committee chaired by His Lordship Justice Gabriel Puaman, has generated unprecedented litigation challenging its constitutional validity, procedural regularity, and legal effectiveness. Critically, several proceedings were filed before her ladyship's removal was finalized. These are contemporaneous constitutional challenges asserting fundamental and irredeemable flaws in the Article 146 process. The removal proceeded despite these pending objections. These objections now remain unresolved before multiple courts of competent jurisdiction. Mr. Speaker, we, the minority, hold a view that there has been inconsistency in the approach in this matter, and that if care is not taken, this country that we all seek investment for may not attract that needed investment. Mr. Speaker, as we speak, the prima facie findings of the Council of State remain unpublished. Two, as we speak, the very report that recommended...
Honorable Member, I thought your reference to this matter was a matter before the House.
Yes, Mr. Speaker.
But what you are talking about is not before the House.
Mr. Speaker, then let me use the phrase well. Let me rephrase it for the purpose of clarity. Mr. Speaker, my submission is to the effect that the matters giving rise for this motion to be taken are such that we, the minority, still believe that there are serious matters for the constitution of our republic. Mr. Speaker, and I say so because today we consider this nomination, and you have made it clear that our approval or otherwise does not bring a finality within the context of the rule of law, which I agree. I'm not contesting that. But it is our view, most respectfully, that one, the fact that the prima facie determination is not in the public space is of concern to us. Two, the fact that the recommendation, the report that gave rise for the final decision of His Excellency the President is also not in the public domain is of concern to us. Mr. Speaker, we contend that for the purposes of transparent democracy, the era where the citizens require information, it should have been an instinctive, inherent decision to have released the report. Because, Mr. Speaker, we hold a view that this was no less a matter because it was dealing with an organ of government, of state, the judiciary. That is our contention. Mr. Speaker.
Honorable Member, as I said, you are complaining about acts of another arm of government.
Mr. Speaker, I hope my time is being stopped.
Not Parliament. Not Parliament.
No.
And those matters are not before Parliament. And so I have consistently guided you and your colleagues to deal with the matter before Parliament. Continue with the others at the proper forum, not the floor of Parliament.
Mr. Speaker, we are not litigating those matters in Parliament. But those matters gave rise to this, what is before us. So what I'm trying to do is to give a background to the very matter before us, Mr. Speaker. Mr. Speaker, the Honorable Eric Opoku in his submission argues with some force that executive manipulation started in Kufuor era. And he tries that we are raising to say that we are acting in double standard. No. Mr. Speaker, in President Kufuor's era, no Chief Justice was removed. Mr. Speaker,
Honorable Member,
Mr. Speaker,
please. Don't want us to go beyond what is before us. Because many of the things that you don't know, you don't have the information. And in fact, I have bought some books. And I'm going to distribute the books, particularly to leaders, so that you read to see the perception that we have given to the people outside there. They are very senior, intelligent people who held high office of state, who have written some books about Ghana politics. I have the books. I bought plenty of copies to distribute to you free to read. I believe that will change your approach to how you go about the business on this floor. The information that I have from experience in this house, if I disclose them, many of the things you say are incorrect. The presidents and former presidents, they know. You don't know.
Mr. Speaker, that the fact that there appears to be some right violation against Justice Araba Esaba Tokunu, we in the minority are unable to support this nomination. Mr. Speaker, the learned Attorney General, in his submission, alluded to the fact that even when Parliament approves this nomination and the court determines otherwise, the executive would be bound to respect it. He was right in saying that when a court makes a pronouncement, the executive will be bound by it. But what he did not say is the conduct of his office in the handling of the very matter that he is saying when there is pronouncement, they would be bound by it. He himself submitted that the rules of court allows for extension of time application to be made. The question we ask is that why didn't the Attorney General, considering the enormity of this matter, act with alacrity? Mr. Speaker, the question that begs for an answer to be done. Why didn't the Attorney General file a defense? He is now saying that we shouldn't worry, and that if there is any positive outcome, the president will be bound by it. But we are interested in the process. The minority in this house is interested in the process, and it is contending that his actions amount to bad faith and denying the respected
Honorable minority leader. Honorable minority leader.
Yes, Mr. Speaker.
I acknowledge that the Attorney General's conduct of conducting proceedings in that court is not before the House. That at all is not. And so please, let's handle what is before us. Then at the appropriate forum, which you are doing, you continue with it. You can just refer that this is what you are doing, but don't go into the details.
Speaker, with respect, Mr. Speaker, just place my time on ice for us to interrogate this preliminary matter. Mr. Speaker, well, I will leave it to you, but I would want to learn. Mr. Speaker, in my submission, I was responding to the Attorney General. These are facts that he has made known to the House. So I was responding to his own argument. I was not saying anything new. It is what he said that I was referring to. But if you say I shouldn't delve deep into
I stopped him.
Mr. Speaker, very
I
well.
stopped him.
Very well.
And I said he should come back to the subject matter on the floor.
Who vehemently opposed just 2 nominations to the Supreme Court. And when they had the opportunity, they brought 7. Their principled argument vanished into thin air. Today, nominations to the Supreme Court. When they had the opportunity, they brought 7 at a go. Today, the same people who opposed this nominee in 2008, I will submit here to and then leave the matters to rest. Thank you so much.
Matter before the judiciary. They can't say because that matter is before the judiciary, Parliament is stopped from also performing its function of lawmaking, of oversight, of these approvals and the rest until they finish adjudicating the matter. So we have to go on with ours. And that is exactly what we are doing. We cannot be stopped. I have given my ruling on this, and you are bound by it. If you are not, you know the rule in our standing orders. You know what to do. If you are not satisfied with that, you also have the courts to go and vindicate your rights. But so far as the matter before us is concerned, let's stick to that matter. Let's go on with that, and then later on you can proceed with whatever you want to do. But for me as Speaker, I preside. I don't judge. I preside. And I'll preside and make sure that what the rules say should happen will happen. At the end of the day, the House will be given the opportunity to take the decision. The rest, you can proceed on after that. Please. So let's move on to the matter before us.
Thank you, Mr. Speaker. Mr. Speaker, I'm guided.
To the fast-track High Court. We appoint to the High Court. So, Mr. Speaker, that clarification would have to be clear. There's nothing like we appoint to the High Court.
Teach them.
And not the fast-track High Court.
Teach them.
When you are appointed to the High Court, you are then assigned to a division of the High Court. Mr. Speaker, this is the point. You don't appoint to the High Court.
Mr. Speaker, Mr. Speaker, Mr. Speaker, it is in the report, page 8. Page 8 of the report. Listen. Page 8 of the report. He was elevated to the High Court in 2000, serving at Sunyane and Kumasi between 2000 and 2003. And later appointed justice to the fast-track High Court. Is it the report? So what's your problem? So, Mr. Speaker, I was speaking to the report exactly how it is captured in the report. Then, Mr. Speaker, you are ruling on the matter that while Parliament is discharging a lawful duty, no court action can stop that, is fortified by this report. And it's interesting we raise this issue for Ghanaians to know. Mr. Speaker, paragraph 27 of the report.
Honorable Member, your leader is on his feet.
Okay.
Yes, please.
Mr. Speaker, I have been trying very hard to get members on this side to listen to opposing views. I urge our colleagues to also pay attention and listen so that we can expedite action on this matter. I'm just appealing to our colleagues on the other side.
Honorable members, please, we need to listen to each other. Honorable Doctor, he represented Parliament at our march against the judiciary. He was among the 11, and he ran all over the field without touching the ball. and he was substituted. So I understand that. Honorable members, please, we only consider and give prior approval to nominees of the President to the Supreme Court. The High Court and the Court of Appeal don't come before the House for prior approval. Please, that is the state of affairs. The process that he went through, I was minority leader. Concerns were expressed, but this was not a matter that came before the House for his approval or otherwise. Not at all. Please, let's go on.
Thank you very much, Mr. Speaker. Mr. Speaker, I was saying that reading...
Mr. Speaker, thank you for the opportunity to add my voice to this debate on the floor. Mr. Speaker, in making